Recognize you.
Thank you very much for giving me the leeway. I will not be very, very long. There are a few issues that I wanted to raise about this bill, and I will do so very, very quickly. So, Mr. Deputy Speaker, the speakers before. Thank you, Mr. Deputy Speaker. Mr. Deputy Speaker, all of the speakers before have done a reasonably good job in terms of looking at a lot of the legal aspects.
Please, the member for Mayaro, I have recognized, and I'm only recognizing the member for Mayaro at this time. Please, we are going fine. Proceed.
Thank you very much, Mr. Deputy Speaker. Mr. Deputy Speaker, I was saying that the members who have spoken before have done a reasonably good job in terms of looking at a lot of the legal issues, legal ramifications in terms of this bill. And I think it is important that I raise a couple matters on behalf of the people of Mayaro who this bill will eventually impact. And why it is important as well, outside of the legal ramifications, we have farmers and fishermen and small business operators who will ultimately be affected by this bill. And while in reviewing the bill, Mr. Deputy Speaker, I saw nothing objectionable in terms of where it will hurt. But there are a few areas that I feel that is important that I raise it with the Attorney General here for his consideration. So when we look at these bills, Mr. Deputy Speaker, we look for mischief, we look to see how it will impact the man on the street. We also look at how this bill, similar type legislation, is affected in other jurisdictions, and perhaps a bit of the effect that's had in those jurisdictions, and perhaps there are some shared learnings that we can pick up from it. So, Mr. Deputy Speaker, by virtue of this Civil Division Bill 2024, just for the records of Hansard, I will establish the fact that this is the right bill I'm speaking on, where we are looking to break up the courts into small claims courts, estate administration office, and civil court. Mr. Deputy Speaker, the bill is designed, in my view, which has been articulated before a bit, to decentralize the civil jurisdiction by creating these three courts. And it's being done by virtue of Clause 5, which is establishing the civil jurisdiction by the High Court. It will be now vested in the civil courts. Clause 14, which now outlines the jurisdiction of the small claims court. And Clause 29, which transfers estate administration from the High Court to a newly established Estates Administration Office. Mr. Deputy Speaker, in looking at the legislation, I saw no part of any of the legislation that infringes the rights of the citizen in any way that creates issues of constitutional rights. I didn't see it. I looked for opportunities for abuse if there were pieces of the legislation that will ill affect the citizenry. I didn't see much of that either. But there are a couple of areas that I saw would raise some concerns. And if I ask you to bring your attention to Clause 7.2, which permits the court hearings via telephone or video links, that could raise some issues around access to justice for those without the necessary technological resources. So when you look at rural communities, Bish, Matlot, Moruga, parts of Mayaro, where you do have these issues of getting access to telephone, cellular coverage, wireless internet, I feel that there may be some challenges for those people who are seeking some justice and don't have this necessary technological background, and I will address that a little more as we go on. Mr. Deputy Speaker, if I ask you to take a look at Clause 15, in Clause 15, the way how I read it, there seems to be some exclusion of certain matters, and I would probably refer to as like libel and slander from the small claims court. And to me, that could be a bit disadvantageous to some claimants, particularly if they are unable to pursue these matters in the higher court, obviously because of financial impacts to themselves. Mr. Deputy Speaker, the small claim court, from my reading, it caps the monetary limits for claims, meaning that individuals with claims exceeding this limit may need to abandon part of the claim or transfer the case to the civil court, which could impose some additional delays or cost as well. Mr. Deputy Speaker, this is in my reading of it. The cost and complexity sometimes, Mr. Deputy Speaker, in the appeal, I think the member for Port of Spain, I think that was South. Yes, he did raise the matter of the appeal court. And, we need to be very careful that, because of the complexity, it does not become burdensome for some small litigants to get these appeal based on cost and so on. Because if you have a small claim, but the legal requirements to get your matter heard in the appeal court is 3-4 times the cost of your claim, well, then it really puts them at a disadvantage as well. Mr. Deputy Speaker, in looking at the legislation as well, as I mentioned, I looked to see if there were opportunities for abuse. I don't see any in terms of any real way, but, with any sort of judicial reform, by way judgments are enforced, you have people who are participating like bailiffs and so on. Sometimes there are opportunities for misconduct and so on, and perhaps I'm hoping that these are things that will be addressed, as the legislation is passed. And as it goes into operation, that we can look for some of these things. Mr. Deputy Speaker, the issue of the judicial discretion as well. The Chief Justice in this legislation, he holds significant power in assigning judges and court staff, which, while I am absolutely sure it is efficient for the administration, but in our culture, in our society, there is always this perception of fairness and impartiality when you have a one-man decision in this process. So perhaps that can open room for some queries as well. Mr. Deputy Speaker, if I were to ask you to turn your attention to clause 40, which allows for what I see they call the Rules Committee to set the pecuniary jurisdiction for these small courts to determine the values, this could potentially lead to decisions that may restrict access to justice for a lot of these small litigants, because if some of these limits are too low. So that is something that we have to be cognizant of in terms of how do we make sure that we don't take these people away from the opportunity for their claims because the limits are set too low. Mr. Deputy Speaker, there are some improvements that I would like to suggest to the Attorney General. And in doing a bit of the research on the bill, I looked at some other jurisdictions where there is similar legislation and what they have done in those jurisdictions to deal with it. So, Mr. Deputy Speaker, one of the issues that I raised earlier on is that, the bill allows for hearing via telephone, video links. And we do have people in rural communities who may not have access to those services. So, in the United Kingdom, Mr. Deputy Speaker, there is something called the online courts pilot, which included...
What the term is? The term? What's the term?
Online courts pilot.
Okay.
Online courts pilot, which included provisions for support services, such as access to public computers that may be based in libraries, may be based in municipal corporations, and with the guidance for persons who do not have access to that service in their home space. So in the UK, they addressed that particular issue with this online courts pilot. And what that does, Mr. Deputy Speaker, it ensures that disadvantaged citizens can still engage in the judicial process digitally without being left out due to the resource constraints that many of them may have. So my recommendation, Mr. Attorney General, is perhaps to incorporate some provisions to make digital access available for all, particularly in the rural and underserved communities. Mr. Deputy Speaker, the second item that I just want to raise quickly is the issue of cost reduction and simplification for small claims. So the issue that I see at hand is that the current bill, it limits the jurisdiction of small claims courts based on the pecuniary value, but it does not address the cost of accessing justice to the small claims litigants, which can still be prohibitive even if the case qualifies for the small claims court. The improvement opportunity here, Mr. Deputy Speaker, is perhaps streamlining the filing process and fee waivers for low-income claimants. The example in my research, Mr. Deputy Speaker, I saw in New Zealand, they have something called a disputes tribunal, which allowed for informal and low-cost resolution of small claims without requiring legal representation. And many claimants benefit from the fee waivers if they can demonstrate financial hardships as well, Mr. Deputy Speaker. So the recommendation that I would offer to the Attorney General is that if in our small claim court we could adopt simplified procedures, such as allowing claimants to submit cases without requiring the services of a lawyer, or allowing lower income claimants to apply for fee reductions or waivers, Mr. Deputy Speaker. The third item I want to raise quickly, Mr. Deputy Speaker, is on mediation. So clause 25 allows for small claims matters to be referred to mediation, but it does not make it mandatory before hearing. And I think this is important because I think that some pre-trial mediation is critical. So in my research, Madam Speaker, Singapore has small claims tribunals, which they require mediation as a mandatory first step in resolving disputes. Most cases in that system, Madam Speaker, are settled at this stage without the need for a full court hearing, thus saving time and reducing the burden on the judicial system. So, Mr. Attorney General, perhaps if we can consider making some level of mediation mandatory as the first step before the hearing for these claims at the court. This may as well reduce the caseload of the courts and help parties settle disputes amicably without the cost and complexity of a full trial. And in saying that, Madam Speaker, having read recently a book by the name of Courage in Caroni by Ramnarayan Binder, he spoke about the power of the village councils long ago in terms of the mediation powers that village council had, and many matters never ended up in the courts. So the power of mediation, if we were to draw in the experience from our local village council systems 30, 40 years ago, I can see the validity in having mediation as something mandatory in these cases. Mr. Deputy Speaker, Madam Speaker, enhanced consumer protection. The issue that I've seen coming up here is the exclusion of certain claims. I referred to it before, like libel and slander from the jurisdiction of the small court. It can leave some individuals vulnerable without affordable avenues for legal redress, especially on cases involving defamation on social media. Now, Madam Speaker, that is a big issue today with the push on social media and the uncontrolled way how, you can be defamed very, very easily. So in looking at how that was remedied in other jurisdictions, I saw Australia has something called an Untrader Disputes Tribunal, where it allowed for small value defamation claims related to online disputes or complaints to be heard, providing it for ordinary citizens to address grievances that may not meet the high bar that is required for the higher courts, the larger courts. So I'd like to recommend, Mr. Attorney General, that we consider allowing limited jurisdictions for defamation claims or protection disputes within the small claims court, particularly focusing on online and digital cases where damages are small, but the reputational damage can still be significant at the end of the day. Madam Speaker, public awareness and legal education. In looking at the bill, I did not see any explicit opportunity for provisions of public education to support the navigation of this whole new legal framework. And I'm thinking that is a big issue that perhaps we ought to address, if not in the legislation, but as you go out to operationalize the changes, that it remains part of the focus of your office as well. Again, the research showed that in South Africa, there is something called a Small Claims Court User Guide, where public education campaigns were launched to educate citizens on how to use the Small Claims Court very effectively, and that worked very well. In the United States, Mr. Attorney General, many jurisdictions provide pro se self-representation, which I think was spoken about by one of the speakers before. But we can do guides to assist the individuals to navigate these small claims procedures. So perhaps if you can look at that as you go to operationalize these changes going forward. Lastly, Madam Speaker, in terms of court specialization and training, I know my colleague from Caroni Central did speak about this issue of specialization and training. The bill introduces these specialized courts, but it does not specify detailed training requirements for judicial officers. So in the United Kingdom, in my research, judges and magistrates, they receive specialized training when they are assigned to specific divisions like family law, civil disputes, small claims. This ensures that the judicial officers are well prepared to handle the nuances of these types of cases that may arise. So if that is something in the operationalization of this legislation, that some sort of specialized training happens, I think it will work well in terms of the delivery of this service. So, Madam Speaker, by drawing on these best practices from other jurisdictions, which I have now spoken about, I think this civil division bill can be refined to better service the needs of the public, reduce costs, ensure a fair and transparent judicial process. Implementing these improvements would provide more equitable access to justice and enhance the accountability and efficiency of these new judicial structures. So, Madam Speaker, thank you very much for the opportunity to raise these few matters, and I trust that the Attorney General will look at it. Thank you very much.